You can't start your business day by thinking, "Oh, I'm going to collect data on as many people as possible today." You need a lawful reason in addition to only collecting data for specific, explicit, and legitimate purposes. This is the second principle of the GDPR and the corresponding UK data protection legislation. What does this actually mean? Put simply, the requirements of this principle mean you must be clear from the outset as to why you are collecting the data and what you intend to do with it. You must specify the purposes for the processing of the data and inform individuals about these. Ensure that if you intend to use existing data in a new way, that it is compatible with the existing purpose. Let's look at each of these individually. Being clear from the outset. Being clear, open and honest with individuals about why data is being processed is a key part of the transparency principle, which was explained in our last video. The easiest way to do this is to place it clearly in your privacy information. Specifying purposes. Additionally, by specifying the purposes at the outset, you are able to avoid function creep, which is the result of your organisation changing how it uses data over time, as your internal processes change. This can be avoided by reviewing your processing purposes at set intervals, for example, every 3 to 6 months. Once again, the best way to let individuals know the purposes are through your organisation's privacy notice or privacy policy. Using existing data in a new way. Let's say you were involved in a work-related car accident whilst driving a company car. The controller or your company would have a lawful reason for asking the other driver for their insurance details, for example, to make a claim for the damage to the vehicle. What the company couldn't then do is use that information for the new purpose of sending company product offers to the driver involved in the crash. By using this as an example, it may help you identify which existing datasets can be used in a different way. The legal wording is that the new purpose needs to be compatible, which does leave some room for manoeuvre. When considering compatibility, you should consider the following. Is there a direct link between the original and the new purpose? The context in which you originally collected the data, and if the individual would actually expect the data to be used in this new way. The nature of the personal data. If the data is sensitive, be very considerate. Whether there are sufficient data safeguards, for example, encrypting or anonymizing the data. In general, the closer the link between the old purpose and the new purpose, the more likely you are going to be able to use the existing data for the new purpose. If you feel the purposes are incompatible, you may seek the consent of the relevant individuals to change the use of that data to encompass the new purpose. It is also worth noting that the GDPR specifically states that where organisations are wishing to use data for archiving purposes in the public interest, for scientific or historical research purposes, or for statistical purposes, if appropriate safeguards are in place, these are automatically compatible. If you would like any further information, consider taking our Level 1 course, available online at www.griffinhouseconsultancy.co.uk. I've been Jane for the Griffin House Consultancy. Thank you for watching.